be impeached by a man named Mr. Whitehurst, an FBI agent out of Washington, D.C. Let's talk, if we can, firstly, and reset this whole argument about Roger Martz. What did you feel about his testimony in the defense phase?
Well, Kathleen, if you remember back in July when Martz testified, he initially came on the stand as, and in fact, he came on the stand as a defense witness. He was called by the defense. And he seemed to indicate in his initial testimony that he found EDTA, and that his findings were all consistent with the presence of EDTA on the back gate and on the socks. Then there was a break of sorts, and apparently something happened during the break, because he came back on the stand and he sort of reversed himself and took the position that he could not say that EDTA was present. And in fact, he indicated that he was not very truthful the first time around, and that he felt it imperative that at this point that he tell the truth. And I found that sort of testimony to be very questionable and very suspicious in nature.
And now,
it raised a lot of red flags in my mind, Kathleen.
And apparently also in Frederick Whitehurst's mind, the FBI agent who was on Primetime Live last night, who apparently is going to give what the defense is calling critical testimony to offer that, in fact, the FBI lab has sometimes enhanced some of the reports to favor the prosecution. Now, can you explain to me about the FBI lab, some of its procedures, and also about what happened in the New York City bombing case?
Well, Kathleen, obviously it would take a significant amount of time to talk about FBI procedures. The FBI is considered to be the premier forensic laboratory, not only in the United States, but in the world. And in the FBI, in the World Trade Center case, they apparently were unable to find any explosive residues at the scene of the bombing. But there were some statements made that certain materials found in the possession of the defendants could have comprised or could have been the components of the bomb. And apparently, I believe that is what the White House was contesting in his program yesterday, or the portion of the program that he was on ABC. So it's very disturbing to find that apparently an FBI analyst, a scientist, a person that we believe or we hope is not biased, that was slanting his views and his findings to favor one side of a criminal case over another, and that these findings, in fact, had no basis in science.
So Roger Martz did testify in the New York City bombing case, correctly, to this, that he did find this explosive or whatever.
That's correct.
And then also there was certain impeachment then at that trial by Frederick Whitehurst, wasn't there?
That I don't know, Kathleen, because I believe there was some impeachments by Frederick Whitehouse, not at the initial trial, but I believe there's a trial in progress right now where Whitehouse was called as a witness.
All right. Jill, are you familiar with this case? I mean, was Whitehurst called in this case? Do you know?
As I understand it, he testified in a separate hearing, in an investigation into this. That was my understanding. And I think that lends tremendous credibility to his testimony here. If this is somebody who had never before spoken out about FBI procedures and came forward in this trial, the inference would be he's a hired gun. But evidently he has gone public with the allegations that there's an overall policy of slanting things toward the prosecution viewpoint, and that this particular agent on this particular occasion did exactly that. So there's what the defense is going to say is that there's a pattern of conduct by this particular individual.
Christina, I'm going to put you on the spot because I know you're leaving in the hour. Do you think it's going to be admissible or not, this witness?
I think Judge Ito could very well say it's collateral evidence because there's not enough indication that he did it in this case, just like he did with Mark Furman's fabricating material.
Kathleen, can I just say a few words here? I think it's very important to understand that in this case, in the O.J. case, that the defense had the opportunity to test the blood in question. There was enough blood that they could have sent these materials to their own laboratories for analysis if they indeed felt that the FBI fudged the data or that the FBI data was incorrect. And the defense team chose not to do so. So I think that's a very important point to make in this case, as opposed to a bombing case where there is no residual material left to analyze.
Because this is basically, when you talk about the material, it's the material that the defense wants us to believe was planted. I mean, so the residue of EDTA on the socks, and how about the EDTA on O.J. Simpson's blood vial itself? So do you know if they've tested any of the blood for EDTA, or have they just not turned over those notes and we don't know?
We just don't know. All we know is that there was no testimony presented by the defense side based on their own analysis of the blood. If you remember, Dr. Fred Reeders testified on behalf of the defense, but he relied on the FBI data.
All right, and Jill, I mean, they can't actually, the prosecution can't get that in any way, or can they get it in a jury instruction that the defense could have tested the EDTA if they wanted?
They can make that argument that, you know, that material was available to them and where are the results, because there is a jury instruction that talks about producing weaker versus stronger testimony or not explaining things that are obvious. So they can make that argument.
We're awaiting the testimony of FBI agent Douglas Dietrich, who is going to be another prosecution witness in the rebuttal phase. We're going away for a commercial break. And Dick, if you could stay on the line, that'd be great. And please send us faxes, any kind of evidence. This is your chance. You've got the expert on the phone and two legal beagles here, 213-954-2691. Best way to fax us. But also you can call us on the 1-800 number. We'll take the question and get it in on the air. I have gotten nothing from you guys. Come on. This is your time. You've been sitting around all these months with those questions. Stay with us. There is a long recess this morning because the judge wanted to give the defense the opportunity to do a kind of to discuss what Douglas Dietrich, the FBI agent, is going to testify to this morning, as he is here to impeach the testimony of Dr. Henry Lee, who talks about the imprints on the back of Ronald Goldman's jeans and also on the envelope that were at the Bundy scene, and if those parallel lines suggest a footprint. With us, Jill Lansing this morning, as well as Christina, and also on the phone is Richard Saferstein, who's the author of Criminalistcs. And if we can, Richard, let's talk about this. We got a call from Richard in Santa Monica, and thanks for relaying it, Richard, about Doug Dietrich, how he is going to be able to impeach the testimony of Henry Lee. I mean, is it this is going to be very difficult. This is all subject to interpretation. So we're going to see the evidence once again this morning. And how do you determine parallel lines, and do parallel lines really show a shoe print?
Well, Kathleen, I think it's not proper to think in terms of impeaching Henry Lee.
You know, that's an interesting point you make, and I want to stop you, because even the judge didn't want Hank Goldberg to do that on cross-examination.
Exactly. All we're going to see here, and we saw this with Dr. Lakshmanan, with the medical examiner, when he was giving some theories as to what he thought happened during the commission of the murder, and Dr. Baden came on and gave his theories, and this is all very subjective, and this is what we're going to see today. We're going to see one side come on and present alternate theories. It doesn't mean that the other side was wrong or right. It just means that there are many explanations for what was observed. But, you know, Kathleen, I do want to say this, that when Henry Lee testified, he did a splendid job on the stand, and particularly on direct. Barry Scheck did a masterful job in carrying him through direct examination, and it made his maybes and could-bes and should-bes sound very authoritative and gave a lot of weight to it. On the other hand, Hank Goldberg did, in my opinion, a very poor job in cross-examining Henry Lee. And the bottom line there was that the image of Henry Lee in that courtroom was bolstered. Now, whether Boziak's testimony can overcome that impression that I believe was left with the jury.
Yeah, even though it's not
to be seen.
Yeah, it's Doug Dietrich, actually.
I'm sorry.
See, you did the same thing I did. You know, it's like, this is on the Trivial Pursuit question, Richard. How many FBI agents have been associated with this trial?
Okay,
right?
So we have Dietrich coming up now?
Mm-hmm. Supposedly we're going to be
Dietrich. I thought it was Boziak.
That's right, because Boziak was the footprint guy. I mean, he was the, actually, no, wait, I should go on to say, Boziak was the man, if I recall, who testified to the rarity of the Bruno Maillet shoe, correct?
Exactly.
Right. So we're actually going to have, that's what's interesting about Doug Dietrich. This is the guy that was supposed to be the hair and fiber guy, right?
Well, Kathleen,
now, there's Boziak on the screen for all of you if you follow at home. This is, I'm sorry, this is Doug Dietrich. I'm sorry. We have so many. We have Martz, Dietrich, Bodziak.
And Martz, yeah. But Kathleen, for the life of me, I don't know what Dietrich is going to add to his previous testimony. The judge has excluded the admission of the report on the rarity.
I know. Isn't that weird?
Fibers.
I know. Why did they? Is it because they have him? They just want him to do something? Because that was why, obviously, the prosecution wanted him in, because of the rarity of the bronchofibers. Well, they didn't get that in.
Kathleen, you got me. I don't know.
I'm very confused, too.
I don't see what he's going to add to this case at this point.
Is he qualified? I mean, I don't understand, and you understand the criminalistics and how it works within the FBI. Are there specialties where some people just do shoes like Bodziak does, rarity of shoes? Do some people do just hair and fiber, for instance, like we already know Doug Dietrich does? If he does hair and fiber, then how can he testify to Schuprin? I'm a little confused.
Well, I'm confused as well, but Kathleen, the FBI laboratory is very compartmentalized in its structure, and everybody there pretty much is a specialist. So Dietrich's specialty is hairs and fibers. Boziak's specialty is footprints and impression. And I don't see how Dietrich is going to be able to testify on the other area unless he perhaps has done work in that area many years ago. But we'll have to wait and see. My impression of Dietrich is that he's strictly a hair and fiber man, and he was qualified as such when he testified earlier in the trial.
All right, then I can tell you one piece of information. Yesterday afternoon, for at least an hour back in the judge's chambers, the LAPD had actually brought down two pieces of evidence in this case, Ron Goldman's shirt and Ron Goldman's jeans. So is there anything more that can actually be made off of those two pieces of the physical evidence from the next witness, Doug Dietrich? Do you know of anything or anything outstanding in your head after you revisit the hair and fiber testimony in your mind?
No. No, I don't, Kathleen.
All right. Now, Bill Stanley has a question. He faxed us this morning. And I have heard this, excuse me while I clear my voice. Richard, a lot of people have asked this question. And I don't know. I just find it fascinating because people are really interested in it. Didn't a hair and fiber expert earlier testify in the trial that an African-American hair discovered on the knit cap was treated? I believe so. Isn't that correct, Richard?
I don't recall that testimony, Kathleen.
I think there was treated, but then perhaps this treatment, Bill Stanley goes on to say, was in fact a black dye to cover the perpetrator's graying hair. Wasn't O.J.'s hair much darker last year after the arrest? Shouldn't the prosecution invite the jury to view O.J.'s scalp now that the treated hair has grown out?
Kathleen, I reviewed the testimony on videotape a couple of weeks ago of Doug Dietrich, and I don't, for the life of me, I don't recall him saying that the hairs he found were treated.
Mm-hmm. All right, that's interesting, because isn't that funny? Because in my recollection, I have that too. And Jill, you have that too?
I do too, and that's why they put O.J. Simpson's barber on to say that she never dyed his hair. He did get gray hair, but she plucked it out. That was the purpose of that testimony, was to deal with the fact that some of the hair in the knit cap had apparently been treated.
All right, whatever that means,
well,
treated.
Captain, let me add this. If indeed that is the case, that adds another important factor to the comparison and further narrows the possibility that the hairs in question came from O.J. Simpson.
Mm-hmm. Now, let me ask you, about these extra hairs. I got to ask you this. It kind of bothers me. I mean, we have what there's called this fourth hair on the Bundy knit cap.
Correct.
Now, how much fiber, for instance, when someone says fourth hair on a Bundy knit cap, could they have made any kind of conjectures as to who that fourth hair possibly belongs to by just its examination of it being a black hair that is, or a black rooted hair that is dyed blonde? I mean, that's as far as they can, and it didn't match Nicole Brown Simpson's.
Well, it would be very speculative, Kathleen. The only thing that really has any value in a forensic hair comparison is when we can take a hair found at a crime scene and compare it to a particular individual. And if we don't have an individual to compare that hair to, the hair really has very little value as forensic evidence.
I am so surprised, Richard, that in some of the policemen I've talked to who were at Rockingham, that every single one of them had hair removed and different kind of trace evidence and even fibers from their shirt, and they meticulously were examined as to their shoes, their fiber on the clothing that they were wearing, and also on their hair. I mean, I find, is that normal?
No, it's not normal, but Kathleen, this is not a normal case.
All right. Well, Richard Saferstein, I can't, and it's not a normal day either. And it's so nice to have you on the air with us for the last half hour. I appreciate all your time so much, and I'm looking forward to meeting you. But this is a great book, folks. I mean, I I love this book. It's Criminalistics, An Introduction to Forensic Science, and you can order this from your local bookstore. The author, of course, Richard Saferstein, who's been with us the last half hour. Richard, thank you once again.
Thank you for having me, Kathleen.
We're going to go away for commercial break. An hour is not an hour in this trial. We're going to see what's happening. We're expecting the prosecution to bring in its next witness in its rebuttal phase, and another FBI agent. Stay with us. The mystery witness no longer on the part of the defense. The man they said that they were going to bring in at the end of the week last night on Primetime Live with numerous allegations against the FBI lab techniques and technicians. Frederick Whitehurst is his name, and we expect that the defense wants to call him. And the point is to impeach the testimony of another FBI agent, Roger Martz, who testified to that there were small and insignificant and nothing unusual about the EDTA amounts on the blood that were on the socks at the foot of O.J. Simpson's bed. Roger Martz. So we revisit him this morning, if we can, to take you back to what Richard Saferstein was talking to. Jill, we are all questioning what exactly did Roger Martz say that morning after he came back and talked to the prosecutors. We're going to bring you just a little snippet now, the cross-examination by Robert Blazier of FBI agent Roger Martz.
Agent Martz, you testified yesterday that you had no bias one way or the other, either for the prosecution or for the defense. Do you remember that?
That's correct.
Is that your state of mind as you sit there today?
Yes.
Now, yesterday morning, recall my asking you questions and you answering the questions before the break?
Yes.
And you recall, after the break, you changed your demeanor, didn't you?
I think I did, yes.
And by the way, during Dr. Reeder's testimony, you were consulting with prosecutors throughout the course of that examination, were you not?
I think, yes, I was.
And you were providing them with possible questions or issues that they should raise?
Yes, I did.
And you were providing them with Ms. Clark with instruction as to what questions she might raise and what technological issues she might raise?
Well, like with them, with you, anything that you asked and they asked, I provided.
During each break, were you down there conferring with the prosecutors, in this case, while Dr. Reeders was testifying?
I don't know about each break. I did confer with them when they asked questions, yes.
And you were conferring with them during the course of my questioning of Dr. Reeders, correct?
When they asked questions, I answered them.
And during the break yesterday morning, did you meet with the prosecutors?
I stepped down and talked with them, yes.
You talked to them about your testimony?
Somewhat.
And you decided after the break that you needed to be much more of an advocate, didn't you?
No,
Did you decide at the break that you needed to be much more of an advocate?
No.
Did you decide that you had to be much more aggressive?
I think I decided that I had to be more truthful. I was not telling the whole truth with yes and no answers.
So you decided to change your demeanor?
Well, I decided that I wanted to tell the whole truth.
To tell the whole truth, was it or not? Was the defense onto something? And did they know about Frederick Whitehurst at the time? Because it's the mystery witness, Frederick Whitehurst, who the defense plans to bring into this courtroom to say that, quote, the FBI routinely encourages agents to tailor testimony in favor of the prosecution, hence impeaching Roger Martz. Now, Jill Lansing joins us, as I said, and I don't know how often, because I know some of you are going around, so I'm constantly saying the reintroduction of Jill and Christina. So I apologize for those of you who I've said numerous times during the past hour and a half. Is this important enough testimony to revisit it and get it impeached?
I think the judge is going to have to decide is number one, is it impeaching? He has given his results in this particular case. And the defense position is going to be that the evidence they have shows that first there's this pattern of the FBI slanting their testimony to the benefit of the prosecution, and secondly that this particular officer in the past, this particular FBI agent has in the past done exactly that. There's no evidence that he's done it here. So if we try to parallel it with the Furman rulings, I would say it's very likely that the judge is going to say since there's no evidence that he tampered with the evidence in this case, it's not admissible, and the defense is going to be saying it's a pattern of conduct, and you can't trust him because he's known to have behaved this way in the past.
Both of you would have told me today, honestly, if you thought there was any hint that this man, Frederick Whitehurst, could actually be put on as a witness. And both of you are basically saying, no go. Hence, what's really going on?
Well, I think they want to make every effort to put him on. The fact that you know the judge may say no to you doesn't mean you don't ask, for a variety of reasons. Number one, he may say yes. So certainly you want to take a go at it, and secondly, you want to preserve your record for appeal, because if we have a number of areas where the Court of Appeal says you should have ruled differently than when you put them all together, it could have made a difference in the trial.
My prediction that he wouldn't put it on, Kathleen, is based on what he did with something similar in the Furman tapes. I don't agree with the Furman decision. I don't agree here. I think any evidence of law enforcement fabrication, tampering, and mishandling is directly relevant to credibility and impeachment and should be in there for the jury to consider. I understand the legal basis for Judge Ito's decision with the Furman tape and this one. I just don't agree. I'm just making this prediction based on what he did before, not what I think should occur.
You know, Frederick Whitehurst could just be a huge boon for this defense team, in that just not only impeaching one witness, but it says this is a man who wants to say this is what we do at the FBI, which brings in the testimony of William Bodziak about the footprints and the rarity of the Bruno Maillet shoes, which brings not only up the testimony of Roger Martz regarding EDTA, but then even comes to the next witness this morning, who is Doug Dietrich, the hair and fiber evidence, which many people believe, if there is any evidence that a juror wanted to hang their hat on, if you don't believe DNA, it's very hard for you not to believe the hair and trace evidence in this case. I mean, so that would be kind of this extra effect that Frederick Whitehurst would have.
I think the ripple effect, first we saw it with Furman, although the jury didn't hear his comments that this is what all officers do. There's a sense that we would have assumed he was telling the truth. We now know that he wasn't. So how do we know who to believe? And this sullies the FBI if this comes in and puts all the results in question.
And gosh knows, Kathleen, the defense needs something to sully the FBI as to Mr. Bodziak's footprint evidence and erase the performance of F. Lee Bailey. Remember that. What if there were two assailants wearing size 12 Bruno Maillet?
Well, even if this guy does come in, at least they still have the gloves, if you believe Mr. Rubin was a credible witness, because he was not an FBI agent, but did exactly what the other FBI agents did in the case, presented the evidence against O.J. Simpson, the physical evidence.
But the difference is he said they're the same type of glove. He never said this is the same glove.
Oh, but Jill, he's 100% certain.
That it's the same type.
Same type.
But not that it is the glove, and I think the fact that there was this photograph that piqued his interest that he thought showed a defect on the glove, and when he examined the crime scene gloves, that defect wasn't there. That alone, it doesn't mean much, but the fact that the prosecution didn't produce that picture and seemed to be hiding it from the jury is something the defense can make much of, and I expect will.
Kathleen, I think you're making a great point about soundbite advocacy when you use the phrase 100% certain, because people hear that and they think 100% certain, same glove. We know, because we were sitting there watching everything and monitoring every word, that he's 100% certain it's the same type of glove. We saw this earlier with the sports doctor who examined O.J. Simpson and who, if you're listening carefully, only said O.J. Simpson, with his arthritis, could have killed these victims given a very specific, narrow hypothetical, if they were motionless and in a laying down position or whatever. However, on soundbite advocacy, what you heard was O.J. Simpson could have done this easily.
Well, that's what all of you fight, isn't it now? Especially you know more than ever, Jill. I mean, after you went through the Menendez trial, of the difficulty for many people. When you pull sound bites, it takes it out of the context of the testimony. But is that where a juror is now with the preponderance of television news clips and 10-second sound bites? Do jurors hear in 10, 15-second sound bites, or are they able to still put into context?
Well, that's what the closing argument is all about, because you will see from the prosecution their sound bites that work. You will hear from the defense the explanation why those sound bites are not complete, and vice versa. So each side is going to try to maximize the benefit by highlighting what was good for them, and the other side's going to be saying, no, wait a minute, look at the whole sentence, look at the whole paragraph. And that's where they try to keep the jury centered.
All right, we're going to go away for commercial break, and we continue. Supposedly, we were going to begin testimony 45 minutes ago. Stay with us.
DNA testing, which is expected to figure prominently in the case.
I've seen 4 of the possible 6.
You saw the brochure stitching?
Yes, I did.
The palm bent?
Yes, I did. Based on what I've seen, I would say that this is Styles 70263, size extra large brown, knowing that I had measured the defendant's hand.
And how certain are you of that?
I'm 100% certain.
100% certain of the style. That's where the 100% certain. We were just talking about soundbite-itis. Belinda, you're on the line from, is it true, Saudi Daisy, Tennessee?
Yes, ma'am.
How are you?
I'm fine, thank you very much.
Good. Now, this is Jill Lansing. You know Christina.
Yes, ma'am.
Do you have a question?
Yes, actually, I do have a question. I don't understand what the big deal is about the hair and fiber evidence, because the blanket that was brought out on the scene, O.J., Nicole, and the children were always back and forth. Also, I thought it was very strange that a hat and a glove from a murderer would be right next to each other under a bush. If there was a battle going on, I'm not going to pull the hat and glove off a fellow and say, excuse me a moment, let me lay this down under this bush in the same spot.
Outside of the gate.
Exactly. So, I think that even if the gloves belong to O.J. Simpson, they had shrank. He has children. My children always played with my husband's hats and gloves. I don't care if it was 100 degrees outside. There's 2 gloves. There's the blood of Ron Goldman, maybe Nicole Simpson on them. Mark Furman comes. He gets 1 glove. And I know policemen. I've had policemen in my family. There's a detective I know from California. They are the scum of the earth. And they will do things.
Through your eyes, in what your experiences have been, because yours speak differently than mine, Belinda.
Yes.
And that's important to respect.
Exactly.
But I have to respect your opinion as you can respect mine, right?
Right. Yes,
okay.
The ones that I've come into contact with, and I even know that sometimes they carry guns with them that are not marked, that just in case they get to a little problem, they have a...
Oh, boy. Not fun where you live, because I'll tell you, they don't do that at the LAPD. You can't accuse them. You can accuse the LAPD with Furman of a lot of things, but they don't do that here.
Well, and I think it's not unusual that there would be hair and fiber anywhere. Also, didn't the Ron Chip fellow, didn't he say that Furman had been to the Simpson residence with him before?
You know what's very interesting, and I have to tell you, Belinda, it's very difficult to find O.J.'s house, period. It is actually a very difficult route. It is not, it is very hard to get from Bundy to Rockingham unless you do know the way. And I do know the way, and I still get lost.
We know Ron Chip, I think in his testimony, had said that Furman had gone with him before, off-duty.
Yeah, he had off-duty, and apparently...
See, Furman said he had never been over there before except for that one time when he was called.
Oh, I'm not sure. We'll have to revisit that in the Ship testimony.
I wish you would, because
we'll have Monica check it upstairs.
I think he did say that.
All right, but let me get into something, because I want to talk to these experts, especially, we've been talking about hair and fiber, and that you have also said, Christina, that's something you can take with, it's tactile. See, here is a way that she can dismiss hair and fiber because of that blanket. That blanket. If you are bent out of hair and fiber, that blanket really foils all of your arguments, doesn't it? So do they have to address the blanket once again?
Well, I think that the hair, as I understand it, there's hair actually worked into the cap, which you wouldn't expect to find just from a casual transfer with the blanket. So I'm sure the prosecution is going to pursue that angle, that here's something that's actually interwoven into the knit. So that's not something that it would have been as easy to dismiss. Her other argument that perhaps they were playing with Daddy's hat and happened to be there at the location.
Daddy's knit cap, black knit cap that looks like something that the Navy SEALs wear when they go to kill people.
One of the tabs months ago ran a shot of O.J. at a ski resort wearing a hat that looked very much like that hat. I remember the caption was something like, first to scoop, or first to
It's so amazing because there's so many pictures of the defendant because he has been such a public man. It's what's commanded the interest of this trial, but also that there's so much physical evidence about what he has done, who he has been with, and also his possessions and his gloves and how big his hands are, meaning that he really, in some ways, he didn't use his hands. And you have to remember, I mean, he carried a ball, but he did not use his hands in the NFL as far as blocking or for any extreme reason outside the use of the pigskin. Marion, you're on the line from Cincinnati. How are you?
Oh, fine, thanks. I'm a medical technologist, and I've been called by the prosecution to court for drawing DUIs. And we were always made so aware of how important the chain of custody was in any specimen that you take from a potential person, DUI or whatever, or a drug case. And I remember that some of the information was missing on the evidence envelopes. And in a regular case, like a drug case or an employment drug case or something, wouldn't that be enough to break the case against the person?
Jill?
Well, they have to establish the chain of custody, as you talked about, and I don't really know what was on the envelope, but I assume this is the defense that's not asleep at the switch, so I have to assume that whatever evidence they needed to establish the foundation was there, either through testimony or through the cover of the envelope itself.
Vivian, you're on the line from Lincoln, Oregon. How are you?
Lincoln City.
Oh, Lincoln City. Hi.
From day one. Quick comment and then a question. As far as husbands caring about their children, I had an abusive marriage. He tried to strangle me in front of my 9 children, and if it hadn't been for them jumping on him, I would have been dead. So I don't think men think about that. One. My question is, and I've been dying to ask this, what about this lawsuit against Chris Darden in the L.A. County?
Funny you should mention that. Guess what? No. Don't say a word. Vivian, when we come back, that's where we were going. I'm so glad you asked. You want to stay on the line and then you can ask questions about it?
I do.
Okay.
I've been dying to ask about this.
Great, okay. Chris Darden, the woman who alleges sexual harassment against Chris Darden, since the prosecution's late, or actually the defense is actually probably holding this next witness. Prosecution's time up for rebuttal in just a moment, but we're going to talk about this Chris Darden sexual harassment issue in a minute. Greg has the details downstairs. So, Vivian, stay on the line. We'll be right back.
DNA testing is expected to figure prominently in the case.
All right, Vivian from Lincoln City, Oregon, we're going to answer that question. All right, you're wondering what happened to Chris Darden and that woman?
Well, you said sexual thing.
Well, what's that? I didn't know. Someone said to me sexual in my ear, and I was wondering the same thing.
$12 million lawsuit claimed she was grilled for dirt on O.J. Simpson's first marriage and was pressured to lie at the pain of being arrested and jailed.
Right on the nose. Greg Agnew's on the newsroom, and he can bring you up to speed on that issue. Vivian, Greg?
That's right, Kathleen. Actually, for the first time, the woman is actually speaking out in public. It was earlier this year that she first started complaining about being harassed. It's not so much sexual. It's more a harassment on the professional kind because she works at the DA's office. She's a co-worker of Chris Darden, but she has targeted him and the others for a $12 million suit. Now, she just filed the suit recently, and this is what the actual lawsuit looks like itself. There it is. She is filing suit asking for $12 million. She claims that Darden and the others tried to force her to tell what she knew about O.J.'s first wife, Marguerite. She has extreme claims. This is what she has to say.
If you say, if you answer no to a question that I've asked, and it's later found out that the answer should have been yes, then you could go to prison.
Now, she says that she was forced to adopt and embrace fabrications about Marguerite. What the DA's office wanted her to do, according to her suit, is actually claim things and agree with them when she was talking about things that Marguerite had told her. What she claims, though, is that she doesn't even know Marguerite Simpson, and that's why she's filing the suit for $12 million. The DA's office, through Jill Lansing, says that they are investigating, but nothing wrong was done in this case. Kathleen?
All right, thanks, Greg. Vivian, does that answer your question?
Well, sort of, but if he's accused of this and if they find him guilty of this, is that going to have any effect on the trial or an appeal if they're saying all these people are covering up and doing these things?
Well, let's ask. Jill, Christina, what kind of outcome could that have?
Well, the suit is a civil suit, so she is suing him for money. So it is separate from the criminal trial. But in the process of the civil suit, they can take depositions, they can gather information for that suit, which I would assume, if it has any impact on the criminal case, would be shared with the criminal lawyers if they were in the position of pursuing an appeal at that time.
So at that time, it would be at the discretion of, and let me get this right, the district attorney's office whether to file any charges against its own district, against its own prosecutor?
Well, it seems to me there's an interesting comment that Gil Garcetti has said, we're investigating, and there's been no misconduct. So it sort of seems like they've already either finished their investigation or they've resolved the issue in their mind already.
Yeah, it's no misconduct to them. I mean, and we've already seen Lucienne Coleman come out with a deposition, or not a deposition, but a statement in which, you know, she was somewhat irritated that she didn't feel all the evidence was turned over regarding Mark Furman to the defense team. So you already have rumblings now within your own DA's office in trouble.
Well, certainly if O.J. Simpson were convicted and, you know, your lawyers were trying to devise appellate grounds, one of these grounds could be we've got this newly discovered evidence that there was prosecutorial hanky-panky. Whether a judge would find that to be reversible error is another matter. If O.J. were acquitted, you could possibly use material from this suit to bring a vindictive prosecution civil suit on O.J.'s behalf, although those are very, very hard to win.
Marilyn, you're on the line. How are you?
I'm fine, thank you.
Do you have any questions?
Yes, I do. In the beginning of the case, an envelope was brought in. Everybody assumes it was a knife. It's never been heard from since. When they tried to bring it in, the judge said, this is not the time.
No, I think it has been brought in. It actually was opened up, correct? It was the other hand. Can you explain that one judge went into O.J. Simpson's house and got the knife and put it in a packet, but it's not the same knife, I think, is the problem, Marilyn. I don't think it flushed out the way the prosecutors wanted it to be. Is that what you're referring to?
No, I'm talking about the knife that the defense brought in under seal, and the prosecution was not allowed to see. It was supposed to be impeachment
No,
evidence.
they saw it. They did see it, and William Hodgman saw it, and they talked about it for a long period of time. That's about 5 months ago. What was the judge who went into O.J. Simpson's house to get this, and then it was put under seal? But they've all kind of looked at that knife and thrown it out because it wasn't exact. There were times in which, I guess was in the Lakshmanan testimony, that the prosecutors were able to bring in with Brian Kelberg, all these different knives. Remember? They wanted to show that it could have been this knife, could have been this knife, could have been this knife. However, I don't think at that stage that knife was actually brought out, was it? I'm not sure.
I don't think so, Kathleen. It was an elderly Asian gentleman, a retired judge, who went out there at the request of the defense to show everything would be on the up and up and took possession of this object along with, I believe, garment bags at Kardashian's house. And he came in and testified about what he took from Kardashian's house, but I'm not sure we've actually seen the mysterious object in that famous envelope yet. The prosecutors have seen it, though, during discovery. You're right.
You know, I was just realizing that we've been doing our little Trivial Pursuits. You know, what are the great questions to ask of people who, so you could really tell if somebody really knew what was going on in this trial, for instance, like, name the judges who actually appeared in this case. And you would mention Judge Ito, obviously, and then you'd go ahead with John Reed, and then you'd say, now, Judge Reed, you know, what are the issues that he revisited? Was it one? No, it was 2 issues. So that's a good trivia question. But now it is 3 judges in this case. Remember, we pointed out, that's another great trivia question. His name, by the way, is Judge Delbert Wong. All right, we're going to go away for commercial break, and we'll be right back. We're going to go to noon. They're not going to come back in the courtroom. We're going to take our recess for lunch, which should be at least an hour till 1 or 1:30, but we're going to be staying on the air for the next 10 minutes. Stay with us.
DNA testing, which is expected to figure prominently in the case.
Well, there are moments of levity in this trial. All right, firstly, I have to ask a question, though. Christina, your favorite funny moment?
My favorite funny moment in the whole trial?
Tough, huh? It's easier for you to think of impeaching testimony. Come on, we're going to shift gears. All right, Jill, any funny moment?
I think the waxing and waning had to be really one of the high points of this trial. Because it captured so much of Judge Ito's assuming we're all so much more than we really are, and having to deal with our human limitations.
Come on, Christina, nothing?
You know what? I think it was when Judge Ito was examining a witness who had, Cochran, who had seen Cochran at a social function and said he was with a woman, and he said, but it was my wife, right? It was my wife.
That was a very funny moment. There are a lot of great moments in this trial. We're going to show you waxing and waning later on. That came just this morning. But right now, we want to show you some of the more humorous moments that have come over the last 8 months of testimony. And for all of you who have your VCRs at home, roll tape.
Let's have the jury.
The case won't be over.
7 years, 9 months, 5 days.
Wait! Sustain. Oh, well. I guess, I mean, I didn't, and I guess not.
I was with my wife, right?
Yes, you are.
Okay, good. I'll take the stand. I'll take the stand. I was with my wife. No speculation.
When you start chopping up the DNA, you lose.
Are you the only person that has received both the De Niro Award from the International Group and the Distinguished Criminal Award from the American Academy of Forensic Scientists?
Well, it's distinguished criminalist, not distinguished criminal.
Oh. Did I say that?
Yes.
If I see this conduct again from either of you two...
Mr. Simpson never wore any panties around that house, did he?
Nanny, 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 and neener, neener.
Blah, blah, blah.
As New Yorkers, we talk fast, we move fast.
Not fast enough.
Not fast enough, I know.
Okay.
Was Mr. Blazier there?
Leaving, Your Honor.
Sustain.
Oh, maybe him. You all look alike. I don't. I just thought, these guys are Meshuggah and didn't know what they were up to. So I wasn't particularly watching that carefully what they were observing. But at any rate, Your Honor, what? Well, this is Los Angeles. It's an L.A. pronunciation.
Yeah, but somebody who's a Goldberg, Mr. Goldberg.
Wait!
Sustain. Oh, well, we have an attorney from New York. We have an expert witness from Maryland talking about June weather conditions in Santa Monica. We got a problem here.
I don't think they can stand the truth. That's what Jack Nicholson said. But you don't want to hear the truth. And I think it's very appropriate in this situation. That's exactly what's happening here. There's one other thing I'd like to point out.
He the bad guy? Wasn't he the bad guy?
Yeah, but bad guys say something worthwhile sometimes, Your Honor.
Well, they give you 3 kinds of towels in a hotel. They give you washcloths, hand towels, and bath towels. These are experts on hotel towels.
Size small. I guess it's Mr. Bailey's.
Take about 3 deep breaths. All right, another fascinating day. It's Miller time. Just when you thought we couldn't have anything crazier happen.
I don't think we're going for the same parts.
Bravo. And yes, we'll run it again, but you got to tell me when. All right, we're going to go in for commercial break. We'll be right back.
DNA testing, which is expected to figure prominently in the case.
All right, another fascinating day. It's Miller time. Just when you thought we couldn't have anything crazier happen.
I don't think we're going for the same parts.
No, this isn't the cross-dresser. Yes, to me. This is Steve Seeley, and I just want to thank you very much for putting that piece together, Steve, because he's had some fun, huh? Being able to do that with videotape. Thanks. We really appreciate it. He's got another one coming up for us in the next couple of weeks. As we wrap up for this morning, so what's next, ladies? Where do you think we're going to go? Do you think we're going to get Dietrich on today at all?
I assume. They're reviewing the evidence that's just arrived. They have the lunch hour now.
We don't know what it is yet.
I presume it's photographs. But I don't know. So they certainly have a little extra block of time now during the lunch
Because,
period.
Christina, we didn't expect Doug Dietrich to ever talk about this, this kind of evidence.
No, we didn't, although I think his job title over there covers a few areas forensically, so he can go ahead and testify anything in the hair and fiber area.
Obviously, but Richard Saferstein may have given us an indication of the cross-examination if they want to get to the FBI laboratories being as compartmentalized as they are, and whether this man really does have the authority. Maybe they could be weak on that. We'll have to see.
Maybe in cross-examination we'll see some of the Whitehurst issues coming up.
Yeah, you're probably right. Very good, Jill. Jill Lansing, once again, thanks so much for joining us. We appreciated it for your yeoman's work this morning, as well as Christina. Thank you. We're going away for our break. I'm not sure. Maybe advisory at 1 o'clock. We might be 1:30. See you then.